She was a public defender in Massachusetts. She was a public defender in Seattle, Washington. I had the luck of practicing with her for 6 or 7 years in a law practice in Seattle. And now she is at the National Association of Criminal Defense Lawyers, and her title is
Director of Public Defense Training and Reform.
Director of Public Defense Training and Reform for the entire country. And if you ask, why would she get that job, you're about to find out. Let's go.
This is the Chinese character for crisis. We're living in a country where the incarceration rates are highest in the world. Look at that chart. We are off the charts. In every single moment, 2.3 million people are in prison in the United States, over 1 million African American. We have 5% of the population of the world and 25% of all people imprisoned in the world. And if nothing changes, 1 in 3 black men will go to prison during their lifetime. Since I sat in this room a year ago, these are the visuals that we've been having. It's almost hard for me to talk about what has been going on for the last 2 weeks. To wake up to Alton Sterling, a father of 5, selling CDs, and the very next day, watching Mr. Castile bleeding out in front of us. It is a hard time for all of us as defense lawyers, public defenders, state and federal criminal defense lawyers that go into the courtroom every day. And for us, and all of the people that are sitting here, who've been practicing for 35 years, 30, 15, 10, we have been in courtrooms for me, 26 years, where I've represented clients who have been beaten, have been shot, have been killed. We've known about this, but now America is seeing this. And I can say that for sitting here in this room in this moment, there is absolutely no place that I would rather be. There is no more important job in America than to be a criminal defense lawyer. We are the only people that stand between, we stand next to our clients, and we are the shield. When you hear the thing, when we look at the tallies, last year, 986. It's 2016, 522. But with this Chinese symbol of crisis, it's actually 2 symbols. Danger plus opportunity. And this is our moment. In the last few years, we have coalesced. Jeff Shear, where are you? One of the founding members of the National Association of Public Defenders, NAPD. How many Gideon's people do we have here? Jonathan Rapping, Rapp. So many, to many of us, a warrior for the defense. NACDL has now taken this incredible, now public defense is really our #1 mission. We have seen public defenders who are making differences, and one person can make a difference. Do you remember this scene? This is Bree Newsom, one of the leaders of Black Lives Matter. Enough, she said. And she climbed up on that flagpole. This flag comes down today. One person can make a difference. Does everyone remember this visual from just 2 weeks ago or a week ago in Baton Rouge? And her fierce force is almost propelling the police back. Public defenders, Jamie Tolson in San Francisco, we watched her being handcuffed and taken away in the courtroom for her client. Chris Roth, Hinds County Public Defender, Mississippi, standing next to his client who had given birth 3 months ago and was begging the court to allow her to stay out on release because her 3-month-old needed to be breastfed every 3 hours. He was taken into custody. And Ms. Bakhtari from Las Vegas, who was in this courtroom for the first session of NCDC, when she was advocating that her client doesn't go into custody, but the judge said, I need to take her into custody to teach her a lesson. We are fierce and strong warriors for the defense. One of my best friends, Cynthia Roseberry, says, we as criminal defense lawyers are forced to deal with some of the lowest people on earth, people who have no sense of right and wrong, people who will lie in court to get what they want, people who do not care who gets hurt in the process. It is our job, our sworn duty as criminal defense lawyers to protect our clients from those people. Do I have that commitment for you? So what do we have to do to get there? You gotta take a leap. We gotta be able to say, you know what? For the next 2 weeks, we are gonna step off that cliff because that is the only way that we can represent our clients. And I want to talk to you about theory, theme, and story this morning. You know, every time you stand in front of a podium or every time you stand in front of a jury, if you're state practitioners, you can walk around, we are practicing one of the most ancient arts. We are practicing the art of story. And it is the most addictive thing that we could ever possibly do. We know that people want to hear about story. For me, I grew up on the Jersey Shore, and Jaws absolutely terrified me. I would hear bump, 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 and I would be like, oh my God, there's a shark, Mommy. It scared me, but the power of story. My daughter Kelsey, we slept overnight in Walmart in Florida, and then at the Elliott Bay Bookstore in Seattle because she couldn't wait to get the next edition of Harry Potter. The beautiful words of Dr. Maya Angelou. Johnny Cash and his lyrics. Beyonce, Formation, and then Jay-Z with 99 Problems. Whether it is movies, TV series, song lyrics, poetry, we are addicted to story. But you can't tell your client's story unless you can rock with your client. And for the next 2 weeks, we're going to be talking to you about the most important thing that we can do is to listen to our clients, to hear not only their story about what happened, and Yasmin and I, we've debated back and forth about, you know, how much information, but you really want to settle in with your client. Josh Carton, who's a wonderful jury consultant, was teaching one day, and he said, I'm really having a hard time breaking through with my client of trust. Client is a Hispanic client, a Mexican national. I've got to use an interpreter with him. We're really having barriers. And he said, when you talk about rocking with your client and sitting with him, and you want to get the client's story about what happened, tell your client to pretend that the judge is blind. Have him close his eyes and have him walk through what the scene of that arrest was. What are you seeing, feeling, tasting, smelling? And you do that exercise, and it has changed the way that I've been able to communicate with my clients. You have to establish trust in the clients. You have to brainstorm. This morning we're going to spend a lot of time brainstorming tools, and these are just some of the things that I would do when Jeff and I were in practice. We have whiteboards everywhere, and we want to throw out all the facts onto these whiteboards, the good, the bad, the ugly. We want to put in this case, you can't see it, don't worry about it, but this is the story. Who are some of the characters? What's the client's story? Does it jive with what the evidence is? Who are all of the witnesses in the case? As I said before, you want the good, the bad, the ugly. If your client's DNA is at the scene, you're going to have to deal with it. If your client is seen running from the burning building, you're going to have to deal with it. But oftentimes what seems to be fatal facts are facts that we can use or explain or neutralize. We want to deal with the 5 senses. Can you see the anger in his eyes? Can you hear the crack of his fist on her stomach? Can you taste the blood, the metallic taste of blood on your tongue? Can you smell the steel beer and cigarettes? Thinking about what the five senses are. One of the things, a book that Malcolm Gladwell had written, has anyone ever heard of The Tipping Point? It's a wonderful book. He's also written Blink and I think Outliers, right? One thing about Outliers, which I always found fascinating, is that people say you have to have 10,000 hours behind you before you're an expert. You know, people just don't come out to be experts. We as criminal defense lawyers, the more we practice, the more motions we do, the more trials we do, we become experts. But Malcolm Gladwell in The Tipping Point said, it's this one moment, this threshold, this boiling point where when something happens, life as you previously knew it is never the same. And so when we're asking you to look at your cases that you're here with, what are some of the tipping points in those cases? Was it when the coach walked into that locker room and said, is anyone here? And they came out of the stall. Is that the tipping point for young Audrey Hart? What is the tipping point? Understanding that juries understand universal themes. Fear, anger, jealousy, greed, loyalty, protection, retaliation, all of these things, self-preservation, racism, these are themes that permeate every single aspect of our lives everywhere in this world. And I share this with you because last night Laura Hogue was introducing and said that not only do we have lawyers from Washington, D.C., Washington State, Connecticut, New Jersey, Texas, all over the place, Missouri. We also have lawyers from Sweden, Japan, Peru, Australia. Am I missing anyone? Argentina. And you want to know something? Everything that we talk about here happens in all of those countries as well. I can stand here and with affirmation and say, I know this to be true. I taught in Kenya, in Mombasa and Nairobi, trial skills. And you're sitting here, it's a picture of me sitting at a table with three other lawyers. We've got a 24-year-old lawyer who's new to trial practice. We have a Muslim lawyer who's been practicing for 10 years. We have a judge who was a practitioner and has now been sitting on the bench. And we're brainstorming a murder case. And what the facts are is that there was a tribal chief who was 92 years old that was bludgeoned to death. Suspect, his 19-year-old fifth bride's boyfriend who was 21 years old. And the villagers said that they were having a clandestine affair and that he was jealous and that he must have wanted to kill the old ancient chief. And so all of the universal themes of lust, jealousy, fear, there's snitches. And so, you know, when you say, here I am, far, far and away, the same universal themes played out. Using language that the jury can understand. And everything comes down to theory and theme. Theory and theme help us make the right decisions. You're going to hear from Jeff Robinson talk about voir dire this afternoon. What are some of the questions that we want to be able to talk to our juries about? Not based on stereotypes, but what are your attitudes and your opinions? We want to cull those out. We want to hear the bad stuff. We embrace that, and we're grateful for that, but we can't do it unless we have a theory and theme. What are we going to say in opening statement? What are some of the things that we know in confidence that we can say without worrying about the prosecutor trying to fix it? What can we cross-examine on? What's our goal in cross-examination with each and every witness? Because every witness plays into our theory and theme. Do we need to call witnesses, and what are exhibits? Theory and theme, they really help orchestrate every aspect of the trial. But a theory is not a legal defense. I sat in this courtroom in 1999 as a participant, and Kat Kelly did this lecture, and she said that there's basically 6 legal theories. It never happened. Mistake, setup. Crime never happened. It happened, but I didn't do it. Mistaken identification, alibi, some forensic evidence shows it happened, but I didn't do it. It happened, I did it, but it isn't a crime. Self-defense, accident. It happened, I did it, it was a crime, but it wasn't this crime. I shot the sheriff, I didn't shoot the deputy. You know, I'm not a trafficker, I like to possess drugs. It happened, I did it, it was a crime charge, but I'm not responsible. Insanity. It happened, I did it, it was a crime charge, so what? Dude needed killing, right? And we have any New Hampshire people here? New Hampshire? Oh, they had this wonderful thing, they were trying to get this jury nullification instruction. It was like so fabulous, got shot down. But that's illegal, those are legal defenses, but they're not a theory of the case. Bonnie never knew what was gonna hit her when she walked through the door. It started so softly. Angry words, a push became a shove became a slap became a punch became a kick, and over time, it got worse and worse and worse. Sometimes it was just because the eggs were a little runny. Other times it was because he was so drunk and so angry that there was not enough beer that he would take the last can and throw it at her. But on this day, when she came through the door, it was different, because for months this baby had been growing inside of her, and she hadn't told him yet. And that night when she lay in bed, holding her stomach, she heard the creak of the door, the angry voice, and within seconds, the pummeling. But this time it was different. This time it wasn't just her. It was the baby whose pulse she could almost feel in her stomach. And when that punch came through to her stomach, she did the only thing she could. She grabbed the knife to make it stop. That's a theory of the case. You could do that, or you could say, ladies and gentlemen of the jury, this is a case about self-defense. For years, Bonnie had been subjected to constant, continuous abuse and violence in the household. But something was different because she found out that she was pregnant. And the night when this attack happened, she wanted to protect herself and her baby. So when he was beating her, she took the knife that she had put underneath her pillow, just in case something bad would happen, and she took it and she started to stab him. Ladies and gentlemen, at the close of this evidence, I'm going to ask you to find my client not guilty. That's not a theory of the case because it doesn't have what we want is the combination of facts, law, and emotion. So the theory is, the law, self-defense and defense of others, we want the jury to understand within those first 30 seconds, David Bayou said two sentences, but shortly, what the theory of the case is. What are the facts? She did the only thing she could do to protect herself and her unborn child. What is the emotion? She was terrified. It's a paragraph or less, and then we want the jury to return a favorable verdict. A theme. So that's theory, right? And now we have theme. It's a short statement, a simple truth that's central to the theory of the case and central to a theme. And what it does, it conveys the factual and emotional truth of your story. All right. So good, you're an old dude like us, right? A theme statement. What? Yeah. So where's the beef? Who said that? What company? Mondays. Melts in your mouth, not in your hand. Takes a lick and keeps on ticking. It keeps going and going and going. The rabbit. It's funny. I'm the world's most interesting man. I don't drink beer, but when I do, I drink Dos Equis. That's right. What is his tagline? Stay thirsty, my friends. Right? That's a theme statement. Those are I say go to the calling. Those are marketers. Where's the Beef was like in 1980 something, right? People still know it. M&M's was like 1950s. Timex similarly. These are for really a long time. Sorry. So what you're trying to do when you're thinking about your theme, you're thinking about what would the headline be in this case. If you picked up the story tomorrow, if you picked up the paper tomorrow, what would the headline be in Michael Kittle's case? What's the headline? You want to make sure you're blowing it up with the 5 senses, and as I said, refer to word masters, marketers, people that are wonderful, thoughtful people about how we can get something to stick in one's brain. Patty Hearst, again, long time ago case. 19-year-old kidnapped. She was from the Hearst Foundation, rich girl in Berkeley, kidnapped by the SLA, a leftist terrorist group. We were captivated in America. But all of a sudden, after this woman had been kidnapped, now all of a sudden she's on propaganda. She's on videos, and she's committing crimes for the SLA. She goes to trial because of a bank robbery. And the theme in that case, young, sheltered, kidnapped, raped, kept in a closet, responsible, not guilty. Young, sheltered, kidnapped, raped, kept in a closet, responsible, not guilty. Right? We all remember that. Has anyone seen the ESPN? It's really good. I really encourage you all to watch it. It's wonderful, isn't it? It's addictive. It's a great documentary about O.J. Simpson. But Johnny Cochran, if the gloves don't fit, you must acquit. That was something that every American talked about for a long time. That was the theme. So I want to talk to you, how do you develop a theme? So Jeff and I were getting ready to try a murder case, and the facts are pretty simple. There's a group of African Americans that are in a parking lot, hanging out, talking, just chilling out, playing music. Two white dudes walk through the parking lot. Words are exchanged. A melee breaks out. A young black man, Jesse, is stabbed. His best friends are all within 5 feet of the stabbing at the time it occurs. 2 knives found at the crime scene. Both have the DNA of the victim. One has the defendant's, our client's DNA on one. One has the other, the perp's blood on the other. The prosecutors make the decision based only on the knives that because the sheath was longer on the knife that had my client's de minimis amount of DNA, that they're charging him with first-degree murder. And lo and behold, I don't know if this ever happens to any of you, but the co-defendant becomes the snitch. And we know that he's the actual perpetrator. So Jeff and I sat in our office and we were trying to figure out, there's 5 eyewitnesses, what their stories were. We created this long exhibit that we had all these animations for it. But one of the things that we kept realizing is that all the witnesses were describing the person that committed the stabbing as having dark hair, acne, zits, lots of zits, and a beast tattoo, and wearing wife beater. And some of their descriptions changed, but they all said wearing a wife beater. So this is what we knew, pimples, things, wearing a wife beater. Our client, by the way, was blonde, no acne, no tattoos, wearing a polo shirt. I said to Jeff, I hate the word wife beater. It's so horrible. But Jeff said, Colette, follow the wife beater. That's our theme of the case. And Jeff said to me, after we did all of these demonstrative aids, that we're going to win the case after opening statement. This is ridiculous. You know what, Colette? I'm calling the prosecutor. We're going over there. We're doing the opening statement. I was like, what? The trial's in 2 weeks. We're not doing the opening statement. Follow the wife beater is a theme story. There's no way they can get past it. We go to the prosecutor's office. We do the whole thing, the whole entire opening statement. Not a word from the prosecutor. I was like, we leave. Don't hear a peep. I'm like, we shouldn't have said the wife beater. It's too much. Week before trial, case dismissed. So follow the wife beater turned out to be a good theme. The use of trilogies. People remember things in 3. Johnny Cochran was the king of trilogies. Drugs, sex, rock and roll, the good, the bad, the ugly. Thinking in 3s when you're thinking about your case. Trilogy. Repetition. Free at last, thank God Almighty we're free at last. Repeat, repeat, repeat. Alliteration. The beaten, bloodied, battered body of baby Maddie Epen. Baby buggy bumpers. Be careful. Alliteration. Sex, semen, sweat. Thinking about things that have the same sounds. People like alliteration. And we must answer the big question, the big why. In every case, you can say, why did little Susan lie? Why did Susie say that her stepdad put his penis in her vagina if it didn't happen? Why would a child know about those things if it didn't happen? Why? Why would a man confess to a crime they didn't commit? I could understand you could confess about small stuff, but murder? Why would Mr. Benito, why would he confess if he didn't do it? You must, when you're preparing your theory and theme, answer the big why question. The power of words. We in this room were all wordsmiths, and the difference of one word could be the difference between guilty and not guilty. Think about it. In 1941, actually on December 8th, FDR was speaking to Congress after Pearl Harbor had been attacked. The first draft on December 7th, 1941, a day that will live in world history. Moments before he was going to speak, he changed it. December 7th, 1941, a day that will live in infamy. He cut his whole speech, and his speechwriters were so upset because they had been up all night writing this, and all of a sudden FDR started slashing it and changing words. And it's one of the most celebrated speeches in history. A case that Jeff tried, it was a stabbing in a bar. When asked his client, what did you use? What was done for the stabbing? And he said, I used my shank. What is shank? When I say the word shank, what are some of the words, what do you start thinking of? Prison, right? And so we had to find what's a better word to describe what shank was. And Jeff was asking his client, well, tell me about the knife. Well, it turns out that it was a knife that he used for work. It was a box cutter. And so he called it his 3-inch pocket knife. Where did you get it, says Jeff? Fred Meyer. So during the course of the entire trial, shank was, ladies and gentlemen, he used his 3-inch Fred Meyer pocket knife. It's like, I go to Fred Meyer to get my toiletries, I go to get my pocket knife. It's all very nice. And the jury was starting to use the same thing. Well, he was using his 3-inch Fred Meyer pocket knife. So just by shifting words, it changes the whole attitude and feel of the case. The power of words. Client was at a club with friends, goes outside to smoke a cigarette, and all of a sudden he is jumped by a whole group of guys, white guys. He's beaten, he's kicked, he's pummeled in that parking lot. There's surveillance videos all over the place. Someone calls 911. There's this guy getting beaten up, you better get here fast. When the blues come, all of those guys that were beating the stuffing out of my client, the bouncer is pulling my client up off the ground. He's kind of swagging because he's had some to drink. He's also been beaten badly. And when the police arrive, they think that he's the bad guy. My client, who had just been beaten in the parking lot, is now the bad guy. So what happens? The police beat the shit out of him in a deliberate, brutal, and vicious way. That's what I wanted to say. But instead I used the facts. Within 17 seconds of arriving at the scene, the officers struck Mr. Adams 15 times with batons, tased him twice while he was lying face down in the cement. They hogtied him. They placed a spit mask over his bloodied, beaten face. Words. Their violent attack caused horrible, severe, permanent injuries that are a daily reminder of Mr. Adams of the unprovoked, unjustified, unrelenting attack. Or, every morning when he looks in the mirror, he sees the 5-inch scar that is a remnant of that January night. After he had been hogtied, beaten, and tased, he hadn't done anything. As he was cuffed, and as he was being put into the police car, he turned his head like that, and a small spatter of blood ended up on the police officer's face. She had just found out that she's pregnant by the chief of police that she worked with, and her husband. It should freak out. That's the facts of the case. He was charged with felony assault. So I had to temper myself, because another thing that I talk about with theory, theme, and story is that I was so angry, and I was I grew up in New Jersey. I just moved to Seattle. This was one of the earlier cases I was doing. There was a lot of these terrible, brutal beating cases where our clients were charged with felony assault against the officers. And Jeff had to work with me to temper my language, to bring it from a 10 to a 3. He was constantly, when I'm cross-examining, he's like, draws a 3. And I said, well, what's a 3, Jeff? Bring it down to a 3. So when you have a theory and theme, it's not just what the words are, it's how you communicate that information to your jury. It makes a big difference. When do you start your pretrial, when do you start your theory and theme? When do you start thinking about it?
When you get the case.
When you get the case, right? Do you use theory and theme in bail?
Yes.
Do you use theory and theme in pretrial motions? I think that theory and theme, it's used all the time. You start it right at the very beginning, and it really does permeate every aspect. Theory and theme. I wanted to share this is a pretrial motion theory and theme in a very large-scale federal drug trafficking case. The prosecutor had placed my client in the #1 position. He was considered the kingpin. If I heard the word kingpin once, I heard it 1,000 times. But after meeting with my client, sitting with my client, rocking with my client, reading over a terabyte of electronic and regular discovery, thousands of DA 6 and 7 reports, that's not what was happening. My client was a migrant farm worker who started to sell some drugs or transport them in order to put food on the table. He wasn't a kingpin. He was a migrant farm worker who did what he thought he had to do to put food on the table. So how do I start proving that in pretrial motions? Because the judge, the U.S. attorney, they were treating my client with disdain because the federal government said that after 5 years, he's the #1 guy kingpin. So we started having things like, well, when you are the kingpin, and we know that you executed 30 arrest warrants for all of these men, including the men that we knew that were the kingpin. You took videos and photographs. Not surprisingly, people that were selling drugs, you'd have fancy cars. You'd expect that they'd have lots of drugs. You'd expect scales to weigh the drugs. Large amounts of money hidden in various places. Guns, ammunition, fake IDs. Well, what happened when you search Mr. Santora, the #1, the kingpin's apartment? Why aren't there any videos or photographs? I've looked through everything, every DEA 6 and 7. There are none. I filed motions. Why not? Well, I sent my investigator to California to see where he lived with his family. And does it match what he described to me? This is where the kingpin lived, in a rented 2-bedroom apartment. When the police went in there, it was my client and his wife in one bedroom, sleeping on a mattress on the floor, and the other bedroom was a blow-up mattress where 3 children were sleeping. There were no fancy cars, no fancy jewelry, just the bare bones. Is he a kingpin, or is he a poor migrant farm worker? And using that theory, that theme, through the cross-examination of the special agents, they're very special, through the direct examination of my client, through the direct examination of his wife and 9-year-old daughter, who testified remotely from Fresno, California courtroom about what happened during that search of the apartment. Theory, theme, story. And during the direct examination was very short. The cross-examination took a full day. We learned during the cross-examination of these officers that they claimed they were proficient in Spanish, and by the end of the cross-examination, we found out that the special agent wasn't so special in Spanish, and that my client's 9-year-old daughter had to act as the interpreter. And that sounds a little war story-ish, but I want to share with you, the reason why I share that story is that the judge started to think very differently about my client, starting with that very first motion to suppress. and the theory and theme, and at the time of sentencing, when those same officers were trying to bump him up for being in a supervisory position, judge says, oh, no, no, no. I don't think he was in a supervisory position. Theory, theme. The use of demonstrative aids. In 2016, we must be thinking visually about our cases. How can we make the story come alive? And you can't just like throw up things, you have to really think about, how's it gonna work in the courtroom? And I use this because we'll be talking in the next few days or weeks, is that if you're gonna use a PowerPoint, make sure the plugs work. If you're gonna be using a chalkboard, make sure that the judge or whoever's looking at it can see it. Make sure all the outlets work. And make sure if all of this fails, that you can create the same visual by the use of words. Why? Why would a man confess to a crime he didn't commit? How many of you have clients that have confessed? Oh my goodness gracious, they confess all over the place. How many of you, when you have clients that confess, the juries convict? How many of you hear the judge say, motion granted in a motion to suppress because of, psychological interrogation techniques? We don't win these cases very often, do you? I should say the suppression issues, do you? I'll do a short advertisement. Everyone should take the Reed technique, the Reed School. I am a certified Reed technique law enforcement officer type. I took the course twice in the last 10 years. And I can understand how police interrogate our clients. It was very, very helpful. But they use psychological interrogation techniques, and in some cases, for example, in the Benito case, why would he confess to a crime he didn't commit? Any thoughts real quickly? I'm sorry? Exhaustion. What else? That was good. That was good. No, other than exhaustion, what are other things that people, or our clients in general, might confess to? Fear.
I was going to say in that case, it was
Mental faculties. What other things?
Oftentimes our clients are put in this reverse situation where they actually want to help the police officer.
Absolutely, and after hours of doing this, they think that, geez, if I just say what they want to hear, that this is going to be a good thing. I've had more than 5 clients say, like, I actually really want to be a police officer, and I thought that if I worked with them, that it'd be really good. And they said that maybe I could be like an informant with them, but I actually really want to go to the academy. I'm like, well, if you've got 5 felonies, the academy might not be happy. But there's a myriad of reasons why our clients might do this, but we have to explain that to the jury because, as Jeff will talk to you about in voir dire, and you're going to hear it, people will say continuously, I wouldn't confess to something I didn't do. So you have to create the environment. If your theory and theme is that after hours of continuous questioning, of being offered 2 different choices, you seem like a nice guy, not the kind of guy that would shoot someone in cold blood, but I could see that it happened very quickly. They were struggling over the drugs. The gun discharged accidentally. That's what I can understand. That a judge can understand that. A jury can understand that. So you tell me, are you a cold-blooded murderer, or did this just happen as a result of an accident? Right? I'll take door number 2. And so you want to create that space, perhaps, in the courtroom. What was it like after, if interrogation starts at 11:15 at night, and I didn't do it, and the clock is ticking, and you want to use some kind of demonstratives to show how long this went on, what was told to the person. Tape off the courtroom, bring in a table, get the dimensions. Theory, theme, story, make it come alive. Bring that jury into that interrogation room. I would have my investigators, whether it was, they open up the doors to the interrogation room in the police department where they would do these interrogations, or I got a court order. I would have my investigator go there, video, photograph, take the measurements, and bring it into the courtroom. And for hours and hours. And after 6 hours of sitting in that courtroom, in that small room, saying, I didn't do it. Finally, all right, I did it. And all of the words that have been fed for hours, all of a sudden now are being attributed to Mr. Benito. Tired, exhausted, mental deficiencies. It's similar to a situation like, why would a bear chew off their claw to get out of a trap? Similarly, after hours of being in this interrogation room, he did the only thing that he could do to get out of that room. And he confessed to a crime he didn't commit. As I said before, tone is really important. You could have your theory, you could have your theme, you could have your stories. But if it's said in a way that the jurors can't hear what you're saying, the story is just going to fall flat. I really share this with you because I can't emphasize enough. I don't want to be perceived as someone that's a rabid, angry person, even though inside I might be a rabid, angry person. And I keep coming up with this, race permeates every aspect of what we do. Laura talked about it yesterday. Jeff will be doing a workshop with us on Friday. It's all in the media now, so it's tone. Can they hear your words? So you have to practice, practice, practice. And oftentimes you can use the same words, but it's the tone that's really important. Any blood that spattered on Officer Volpe was an accident, inadvertent, completely unintentional. Jarrell Adams, he no more wanted to be beaten, kicked, punched in that parking lot. He no more wanted the blood pooling in his mouth. He wanted that no more than Officer Volpe wanted to be spattered with his little stick of Mr. Adams' blood. Accidents leading to accusations. This was a night of misperceptions. Boom! Any blood that spattered on Officer Volpe was an accident, inadvertent, completely unintentional. Jarrell Adams, he no more wanted to be kicked, beaten, punched. He no more wanted that blood pooling in his mouth. He wanted that no more than Officer Volpe wanted to be spattered with a very small speck of Mr. Adams' blood. Accidents leading to accusations. This was a night of misperceptions. Where's Jeff? Is Jeff here? Oh, how long did that take for me to get there? In your kitchen?
A while.
Tone. The words have to be heard by our audience. So you just have to think about that when you're tempering and you're sharing your client's story. I want to end with a few words about what it's like to be a public defender, and I'm going to go talk to Jeff Scher again, who has been one of my mentors. We started teaching together many, many years ago, but in the last few years, when I lived in Seattle, Washington, I went from moved from New Jersey to Massachusetts to Seattle. It's very different, but I really started learning to take care of self-preservation, care about myself. I am now a kind of a cheating vegan, but I eat very clean, with the support of Jeff Scher. I started doing yoga, meditation, I run. We have to take care of ourselves. It's like, we can't tell our clients stories if we're so burnt out, and I don't want to sound foo-foo and lala, because a lot of you are practicing in jurisdictions where your caseloads are off the charts. What I do now in my new position is I go all over the country, I sit in courtrooms, I speak to public defenders, and I hear about what's going on in your jurisdictions and how hard it is. You cannot burn out, because we need you. We need you to fight the fight. So, as crazy as it sounds, try to find your quiet mind. I've learned to do breathing exercises. I'm going to ask you all to stand up real quickly. This side of the room, I'm going like, cut the room in half, all right? Make a decision which side you want to be on. This side of the room, I want you to go like this. This side of the room, I want you to go like this. I want you to take 3 deep breaths. You need to sit down now. There's a woman, Ann Cuddy, who wrote an article in the New York York Times, Cuddy, and it was called Power Postures, and it's a TED Talk. I really encourage you to read it. And what she did is these are called power postures, and what it increases your applauserol and it decreases your your fear goes down and your strength goes up, okay? And she calls it fake it till you make it. And if you stand like this, not in front of a jury, or like this, like one woman, in the quiet, like in the bathroom at the courthouse, for 2 minutes, it changes your chemistry. And they swabbed people, so you see the TED Talk, and they found out that people, when you're nervous, you can't find your words. So try to find the power positions, find your voice. The wonderful, in To Kill a Mockingbird, at the end when Atticus Finch, he puts the sleeves up and he starts talking to the jury. And his daughter says, "My God, your daddy doesn't talk like that except for when he's at home." He was speaking in plain language. For the next 2 weeks when we were doing all these exercises, you're not going to be a Abe Hutt or a Karen Smolar, you're going to be yourself. But it's really important to find your own voice. One person can make a difference. In 1961, Clarence Earl Gideon was convicted of a burglary in which he said, "I am innocent." He did not have a lawyer standing next to him. And I'm going to say something that is, whether or not you represent clients in the lowest misdemeanors or the most serious capital cases, every single client counts. I was a felony trial snob for many years. Sitting in the courtrooms now in South Carolina, Tennessee, Mississippi, I am seeing vast majorities, vast poor black communities being decimated because of fees, fines, costs for minor infractions. I stand here proudly to say I am a misdemeanor lawyer. I'm a juvenile lawyer. I'm a felony lawyer. I'm a capital lawyer. Every single case counts. And this man, on his own, in his small cell, with a pencil and a piece of paper, scribbled out a writ to the Supreme Court of the United States. That was the guilty verdict in '61. In 1963, the verdict looked a little different. We, the jury, find the defendant, Clarence Earl Gideon, not guilty. We say all. We have the power to really change lives. In this moment, in this room, we are strong, fierce warriors. And I know that every one of you are here for a special reason, and we are going to leave this. Macon, Georgia, Mercer Law School, better lawyers, more empathetic lawyers, lawyers that are theory, theme, story-driven, and we're going to start seeing a lot of these verdict slips. And even if the verdict slip isn't a not guilty, if our clients see that you are fighting for them and their story is being told, that is a victory. So I thank you. I'm excited to be here and I have fun in the next 2 weeks.